In this report, MUIIWAOYINLOLA writes on the travail of the Senate President, Drive. Bukola Saraki, as the appeal court orders the retrial of the case he had earlier been discharged and acquitted of by the Code of Conduct Tribunal, CCT. About 2 weeks ago, a 3-man appeal court panel ordered the retrial of Senate President, Drive. Bukola Saraki, at the Code of Conduct Tribunal, CCT. The CCT had earlier in June this year discharged and acquitted the politician who had been standing trial since 2015 on an 18-count charge bordering on false declaration of assets brought against him by the federal government. While discharging and acquitting him, the tribunal had held that the evidence proffered against him by the federal government was bereft of probate value and manifestly unreliable to hold the charges against the defendant. Delivering ruling in a no-case submission made by Kanu Agabi, San, on behalf of Saraki, chairman of the tribunal Danladi Umar said the prosecution at the close of the case failed to establish a prima facie case against the defendant. He maintained that the 4 witnesses called by the prosecution to testify in the matter gave contradictory evidence that were manifestly unreliable to convict the defendant or order him to enter his defense. But barely a month after his acquittal, the federal government again, precisely on June 22, filed an 11-ground notice of appeal against the June 14, 2017 judgment of the CCT acquitting Saraki of the charges. When the case came up about 2 weeks ago, Justice Tinued Akomolafe Wilson, who led the other judges in a unanimous judgment, said Saraki should return to the tribunal to face trial on 3 out of 18-count charge of false declaration of assets filed against him. However, the Court of Appeal agreed with the CCT that on 15 counts of the 18 charges filed against the Senate President, it was proved beyond reasonable doubt that the evidence were based on hearsay that have no probate value. The court agreed with the tribunal that the information supplied in the report used to prepare the charge by the federal government against Saraki did not link the Senate President directly with the charges as required by law. The appellate court also held that the federal government erroneously came to the conclusion that onus to prove the 15 charges was on the defendant, whereas it is established fact that the party that alleges must be the one to prove beyond reasonable doubt. With the judgment, the judiciary has once again dismissed all the salacious and sensational claims by the prosecution that Saraki was operating foreign account, collecting double salaries, made anticipatory declaration, failed to declare assets owned by companies in which he has shares. However, pundits are curious that after sweeping gaffe identified in the case of the federal government, the appeal court still felt compelled to save 3 of the counts when the foundation for the entire case ought to have collapsed with the affirmation of the CCT judgment that the entire evidence presented by the prosecution is based on hearsay and a wrong assumption that the burden of proof of innocence of the charges lie on the defense. It could be observed that counts 4, 5, and 6, which the Court of Appeal referred back to the CCT for Saraki to enter its defense, it is evident that the appellate court probably decided in spite of the full details of the facts availed the tribunal.